My name is Bonaventure. Welcome to our commercial class. Today, we are going to look at the court system. That is a structure, composition, and how judiciary and the control of courts by the judiciary. So there is a diagram here. Here, when you look at the apex, it is the Supreme Court. The Supreme Court is the highest court in the land. Downward is followed by the Court of Appeal. And below the Court of Appeal, we have the High Court. The High Court is below the Court of Appeal. The Supreme Court is the highest court in the land. And then we have the Court of Appeal. And then the High Court. And then we also have the Resident Magistrates Court. The Resident Magistrate Court comprises of Resident Magistrate, Senior Principal Magistrate, Principal Magistrate, Chief Magistrate, that way and that way. Senior Principal Resident Magistrate, and then you have Principal Magistrate, Senior Principal Magistrate, and then we have Chief Magistrate. And below them, we have First Class Magistrate Court. Also, we have Second Class Magistrate Court. Upon appeal, they have to appeal to the High Court directly. And also, the First Class Magistrate, also upon appeal, they have to appeal to the High Court directly. And then we also have court martial. For example, if a crime or an offense has been committed by an army officer, or in case of treason, then the court martial will sit, and then they will come up with a verdict, and that verdict, if contested, they can appeal. The appellant may lodge an appeal to the High Court for reversal of that sentence. Also, we have the Qadi's Court. Qadi's Court is actually people from Muslim faith. It deals with matters of especially marriage and other customs that Muslim people profess to. This is Qadi's Court. So we have First Class Magistrate Court down here, Second Class Magistrate, Resident Magistrate Court. We also have Qadi's Court, and then the High Court, and then the Court of Appeal, and the Supreme Court. So let us see how they function. The Supreme Court was established under the Constitution in Article 163 of the Constitution of Kenya, 2010. That's how it came into being. It was established under the Constitution in Article 163 of the Constitution of Kenya, 2010. And it comprises of the following people. We have the Chief Justice. We also have the Deputy Chief Justice and 5 other judges. So in total, the Supreme Court has 7 judges. And the jurisdiction of the Supreme Court is this: to hear and determine presidential election disputes. That's the mandate that first it's charged to hear. 2, to hear and determine appeals from the Court of Appeal or any other court or tribunal as prescribed by the national legislation, if any. So the jurisdiction of the Supreme Court, first and foremost, is to hear and determine presidential election disputes. That is the first jurisdiction. The second jurisdiction is to determine appeals from the Court of Appeal and any other case that it can hear as prescribed by Parliament or legislation, then it can also hear. And then we have the Court of Appeal. Article 164 of the Constitution provides that there is established the Court of Appeal, which shall consist not less than 12 judges, or as may be prescribed by an Act of Parliament. It was established under Article 164, and it will consist of 12 judges, or as may be prescribed by an Act of Parliament, which means the Parliament may even add, depending on depending on how many people seek justice, it may establish that the Court of Appeal judges will be 20. It is at the discretion of Parliament to decide so, basing on facts available to it of people who need maybe to file their case to that court. Also, the Court of Appeal shall be organized and administered in the manner prescribed by Parliament. It will operate in the manner as prescribed by a Parliament, not outside the legislation of Parliament. And also, it shall be headed by a president, who shall be elected by the judges themselves of the Court of Appeal. They come up and elect their own judge, he will be our president, and then work starts that way. The president will not be appointed by the Chief Justice. The judges themselves will appoint among their own a president of the Court of Appeal. And this is its jurisdiction. It hears appeals from the High Court or any other court or tribunal as prescribed by an Act of Parliament, if any. If any. So the mandate of the Court of Appeal is to hear appeals from the High Court. And qualification of a judge, of the Court of Appeal judge, is the same as the qualification of the High Court judge. Only that maybe perhaps the other one has more experience or is more competent, but the qualifications are the same. The qualification that fits a High Court judge and a Court of Appeal are the same. The Court of Appeal has appellate jurisdiction, By appellate jurisdiction, I mean it can hear cases, appeals from High Court. So it has appellate jurisdiction. It has powers to hear appeals from the High Court. From the High Court. And also on matters of law and facts, sometimes matters may be referred to it for interpretation by the High Court, and it would hear such matters also if referred to it for interpretation. It can also hear an appeal referred to it but by the DPP, Director of Public Prosecutions, in a matter of law, in criminal cases. But in civil cases, the appeal can be heard on the following grounds: the decision being contrary to law or to some usage having the force of law. It can also hear the decision having failed to determine the material issue of law. The Court of Appeal can also take charge and hear that case, that appeal. Where there is substantive error or defect in procedure, which may possibly have produced an error in judgment, it can also hear such. In listening to an appeal, the court can this Court of Appeal, when hearing the appeal, it has certain things to do. It can reverse the decision of the High Court. It has that jurisdiction to reverse the decision of the High Court if it thinks or if it deems it not to be fair or to be contrary to the law. It may reverse that decision. Also, it may confirm the decision of the High Court, that the High Court was correct. It may confirm also if the High Court was correct. 3, it also may vary the sentence, but not increase it. It may vary the sentence, but not increase the sentence. It has also that jurisdiction. It has also that jurisdiction. Let us now look at the High Court. The High Court, on the other hand, has unlimited original jurisdiction in civil and criminal cases. It's not limited to civil cases alone, or it's not limited to appeals alone. It has unlimited jurisdiction when it comes to hearing civil and criminal cases, and other powers and jurisdiction as may be conferred on it by the Constitution or any other law. So this court is very powerful. It has an unlimited jurisdiction to hear civil cases, to hear criminal cases, also to hear appeals. But it will not hear cases on matters that exclusively are under the jurisdiction of the Supreme Court. For example, presidential election. The High Court of Kenya will not hear a trial of the presidential election. That is exclusively reserved for the Supreme Court. But it can hear other parliamentary elections, but not the presidential election. Also, the High Court will not deal with the employment, labor relations, and courts concerning and matters concerning environment. We have special courts which also have powers like the High Court, which hears such cases. So the High Court, the case that it will not hear, presidential election and these labor cases, like industrial disputes, that one it will not hear. But for others, it will hear. So it has sweeping powers to hear other cases, but not every case. Like the presidential, the High Court will not hear such a case, and also this labor disputes, the High Court will not hear that. The High Court also has a supervisory role to play. The power of the High Court is to supervise activities of the lower courts. For example, it may issue an order to the lower court if some fundamental rights and freedoms have been abused. The High Court may order a lower court to do certain things. For example, there is what we call writ of habeas corpus. Habeas corpus. In habeas corpus, a High Court may direct a person or an authority wrongly detaining a person, may direct an authority, like wrongly detaining a person in custody, to have him released. The order is to ensure quick trial of a detained person, and also to kind of stop the unlawful detention. It may issue a writ of habeas corpus. Then the person may be brought to court, either dead or alive. The High Court has that jurisdiction. Also, there is a mandamus order. In English, it is said, we command. It is an order directed to a subordinate court or anybody to do a particular thing imposed on it by law, but which it has failed to do. For example, if a court has taken long to issue a judgment, the High Court may come in that you are supposed to issue a judgment within a certain period. Why has it taken so long? It may force that subordinate court to carry out its mandate by issuing the judgment upon a case which had delayed. This judgment delayed so much. Also, there is also another order that High Court may order. It is called certiorari order. Certiorari order, it means to be informed. It is issued to a subordinate court or a tribunal, requiring it to bring its record to the High Court and show cause why the decision should not be challenged. The order is normally issued where there is improper exercise of discretion. Where there is improper exercise of discretion, the High Court may come in and say, no, bring that file, we want to look at it. and then the file will be brought to it. Also, in the records, if some error has occurred and it is notified to the High Court that there is an error, and that lower court wants to proceed with that error, the High Court may come in and correct that situation, that anomaly. And also, if there is breach of natural justice, the natural justice, which I said is procedures have to be followed without biasness. 2, nobody should be condemned unheard. Those are the principles of natural justice, which a High Court may come in to ensure that such principles are followed. There is also another which is called prohibition. It can be directed to a subordinate court or tribunal, prohibiting it from doing an act in excess of its jurisdiction or lack of it. If a subordinate court goes overboard, the High Court may come in and say, no, it cannot be that way. It may prohibit a subordinate court from carrying out what it had intended to do by prohibiting it, or even by allowing it. There is also an order called an order of declaration. This merely declares a legal position without substituting the remedy given by the subordinate courts. The order is usually given where there is dispute as to property, ownership, or any other rights. Then the High Court can come in and say, no, according to the law, it says this and this. But if that court had already awarded the remedy, then it cannot come in. That one, it will not come in. But what it will be, because that might be the discretion of that court. But if the law was not followed, it will come in and say no, it will prohibit that act being carried out by the lower court. The High Court has also exclusive jurisdiction. It is a court of interpretation of law given by the Constitution. If the matter arises from proceedings from a subordinate court, it has a right to interpret that law. And this interpretation, these powers of interpretation, is given to it by the Constitution. So any matter involving a substantive question of law, the court, if it is not certain on how to come up with a decision, it may refer the matter to the High Court for interpretation. The High Court also has admiralty jurisdiction. It can handle disputes arising to the high seas and other navigable waters. Matters pertaining high seas, the Indian Ocean, Atlantic Ocean, the High Court can also deal with such matters. And this law applied by the High Court will be the law of England, because England had such a law. And there's no need enacting our own laws when we have international law which we can refer to, which has been used since time immemorial. So we can also borrow from other civilizations and adopt such a laws, and they can be very helpful to us. Also, the High Court has appellate jurisdiction also to hear appeals also from the subordinate courts, like the first class and the second class, resident magistrate. They can hear appeals from there. But the appeals to the High Court may be on matters of law or of fact. So in hearing this matter, the High Court may confirm that no, the subordinate court was correct, or it may also reverse the decision of in any manner the order appealed against. In any manner of the order appealed against, it may also order it also may vary the decision of the lower court. It may vary, it may confirm, and it may also reverse. Or even it may also make an order that it deems just and equitable to the appellant. The High Court also has jurisdiction in election matters of members of parliament. It has been conferred that power to determine whether a person has been validly elected as a member of the National Assembly, or if the seat of any member to the National Assembly has fallen vacant. The High Court may also come in. If matters are referred to it, to solve that matter. So those are the jurisdictions of the High Court. Those are the jurisdictions of the High Court. And as I told you, the qualifications of the Court of Appeal judges and the High Court judges are the same. The only difference is that it's appellate, it's jurisdiction. It has appellate jurisdiction. It also, for example, it hears appeals from the lower courts on matters of law and facts. It can also hear an appeal referred to it by the Director of Public Prosecution in matters of law in criminal cases. But in civil cases, the appeal can be heard only on the following grounds: the decision being contrary to the law or to some usage having the force of law. The decision having failed to determine the material issues of law. Where there is substantive error or defect in procedure which may possibly have produced an error in judgment, then it can come in. So in listening to an appeal, the High Court can also reverse the decision, confirm or vary the sentence, or increase it. Now, these judges, apart from retirement, normal retirement, they cannot hold office forever if there is a dispute in the way they are conducting the affairs of the court. But there is also laws in place which says how a judge can be removed, how a rogue judge can be removed from office. So if a judge has become rogue, for example, is unable to perform the functions of the office arising from mental or physical incapacity, he can be removed from office. If he has mental illness, he will come up with very confusing judgments. So somebody can go to court and ask that the said judge be removed from office. Also, if a judge has breached a code of conduct prescribed for judges, then he can also be removed from office. Also, if a judge becomes bankrupt, where a judge is unable to meet his commitments as required by any other person, by any peace-loving person out there, if a judge falls into that category of people, then he can also be removed from office. Also, if a judge is incompetent, for example, is unable to hear cases that come before him, is unable to deliver judgments, is unable to hear appeals, then that way is incompetent and he can be removed from office. Or in case of gross misconduct, he can also be removed from office. Also, the Law Society may come up and say, no, this man is unfit to handle this high office. He can also be removed from office. And so, the judiciary is an important arm in the affairs of state. The mighty and the poor all seek justice at the doors of the judiciary. Without the judiciary, without the executive, without the parliament, human beings would be living in a state of anarchy, because everybody will do one will do what he wants, and that will not be a human society anymore. Hence, the three arms of the government, the judiciary, the legislature, the executive, are very important. Very, very important. And mostly the judiciary, because the judiciary has to interpret the law correctly. And without correct interpretation of the law, then the law also, people can misuse that law. They can misuse that law against others. That can be done. Therefore, independence of the judiciary is important. Independence of the judiciary ensures that individuals' rights and freedoms are protected and enforced by the executive. They ensure that individuals' freedoms and rights are protected and enforced by the rule of law. The High Court also ensures that the Constitution is respected and upheld in its entirety. The High Court also guarantees the smooth running of the government, because the government has to run within the precincts of the law, not outside the law. It also ensures that the respect of the rule of law, checks and balances, and ensures that impunity and misuse of power does not happen by issuing sudden orders that this and this should be done this way and that way. So it kind of checks impunity in the affairs of the government, and that is the High Court. And it also ensures the law to be enforced without bias or delay, because justice delayed is justice denied. So that is the High Court. And then other courts like the resident magistrate, second class magistrate, third class, first class, all those are subordinate to the High Court. So my good students, I want you to do a thorough research in what I've taught today. So until next time, goodbye for now. Thank you.